And this one, to me, this is a pretty interesting issue because it really comes into clear focus, brings into clear focus how much control we think we should have over our own persons, our own bodies, our own lives, right? We've got the concepts of individualism and liberty driving us to say, hey, if this democracy is going to work right and stuff, we should be able to have a large amount of control over how we make decisions in our life and where we go with that. And at the end of your life, you have, right, the opportunity quite often to be making decisions about how your life is going to end. And this brings in, again, as I've said many times already, right, a conflict between two values. Same two values that we see with abortion, but from a different perspective, right? Now, instead of at the beginning of life, and control over your body and what you do with your body to bring life into the world or not. Now we're looking at the back end of it where you're controlling your body to possibly end your life, right? And so the question is, through this privacy argument, is there a right to die? Should people be allowed to be making decisions about ending their life in the same way they do all through their life about how they live their life? Because ending your life is, in a real sense, kind of the last big act of living your life, right? Making that decision about how you want to go out. In relation to family, faith, and all kinds of other issues. And yet, right, federal government, state governments are all there saying, you can't kill yourself. Right? It's against the law to commit suicide, which is, right, kind of a weird situation when you think about the practicalities of it, because you can only carry out the punishment of that law on people who are bad at committing suicide, right? But so if you try to commit suicide and fail, we punish you because you violated laws about what the government thinks you should be able to do in your life. Now, they have some real concerns there, right? I mean, there's obviously some things that come into play about end of life that the government certainly has a position on, and one that goes deep into society, right? So this comes to the forefront, right, when people are getting to the end of their life and usually have major medical issues that are impacting the quality of their life. And when you start at the far extreme end of it, we have people who are terminal. They're going to die soon, right? That's a debatable term, but soon. And they're usually in a lot of pain. The folks that are saying, look, I should be able, right, while I'm in my right mind, to choose what happens to me. And of course, there are concerns about, well, in individual cases, we can certainly see good arguments to be made about a person in their life. But we get a whole lot of different concerns if we want to ramp that up to a public policy perspective where we say people can do this. Because then you have to start thinking about all of the individual circumstances that you might have to legislate. And they bring up real issues. For example, the doctor tells you you've got 2 years to live. At the point that a doctor delivers a terminal diagnosis, is that enough to exempt you out of concerns about killing yourself in society? About getting the government out of the way? Do the government still have some interest there in saying, hey, taking your own life is something that we as a society don't want to support? If they said, yes, you could do it when you're in your right mind, what about when you transfer authority over your decisions to someone else, like a spouse? Could they make those same decisions for you? What happens when there are other issues that bring in conflicts of interest, right? Let's say you've got a partner, a spouse that you're absolutely 100% trusting on, and you have a case where you're going to go into dementia and lose your ability to have any kind of effective control in your decision making. You want to sign that over, right, to your partner. But your partner also, right, and you may have even set this up, has a multi-million-dollar life insurance policy that they're going to become rich when you die. Now they're in a position of conflicting interest, right? They have maybe rights to pull the plug on you at some point, but when they do, it makes them rich. Do we as a society want to make that possible by letting, right, decisions like this be made? Does the government have a right to be involved in situations like that and say, whoa, 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 right, there's some conflicts of interest here. We should think about that, right? Most of the time, when most of the time when we have people in these kinds of situations where they're in the life, again, they're in immense pain. There's no chance of a reversal, right? Everything we know about medical technology and medical procedures tells us this is terminal, you're right, done. We're just guessing on what the date is. If that's true, right, and they're in a lot of pain, most of us can probably understand the desire to say, you know what, I just want to have a few more good days and then be done with it, because the rest of it's not going to be very good. So it's not going to be good at all. But most states right now do not allow you to make those decisions. A couple states do. Oregon, I think, maybe Washington State have some state laws that are on the books allowing right to die, but most states don't. So there's a lot, right, that has to be kind of worked through here, and we've got these, again, conflicts of different values here. One that we've seen often enough to know that it's always going to be an issue is parents making decisions for their children, either for a quality of life perspective or religious perspective, right? And of course, the government, the states have a right, an interest in trying to ensure that proper decisions are made and that people are protected. We've had cases where folks of a religious nature that were religiously skeptical, right, of medical intervention have wanted to follow their religious edicts, not necessarily, I mean, ones that we can look at a religious perspective and a religious history and say, this is what this religion really believes, right? So it's not an individual making this up. You have a religion that's in there and says, hey, we have this perspective, and a lot of times it comes down to an argument of a faith argument that God will handle the medical issues either through, right, if it's meant to be changed, it will. If it's not, then it won't be. But that the government and the medical facilities should, personal people shouldn't interfere. Sometimes, right, that's easy enough for adults to work through that because the adults have the right to refuse treatment. While there would be crossing a line in most states to actively end their life, they can, as an adult, refuse medical treatment and die that way. And so it's only an issue this religious way when it comes to parents making this decision for their children. And it becomes really poignant when those children are mentally challenged and don't understand any of what's going on, right? And so you've essentially got parents saying to the government, we want to let children die. And the government saying medical intervention could save them. And so the issue here is, do you violate their religious perspectives and this privacy side on the point of the parents? who think that if they let their child receive this medical care, that may condemn them to hell, or you let them effectively decide to end their child's life. Currently, right, most of what we see is the government comes in and says, we're going to take action here, and y'all are going to have to just reconcile yourself to the fact that we're going to take the child out of the situation with medical help. But that, I mean, if depending upon how much emphasis or power we put behind the issue of privacy and the decisions that lets us make, then it lets these guardians, parents, people with legal authority over individuals to make these kind of decisions. And so it's really a tough situation. Well, that's exactly part of the assertion from the state side of the case, right? That this is child abuse, right? That this is, you're in most cases it's refusal of medical treatment that results in the child either dying or being having a lifelong complication when there are medical treatment that could solve it. But the parents, right, are not making up this argument about their religion. They're just trying to be true to their faith. And so it's difficult that way. The governments have generally said, state governments in particular, have generally said, while you don't believe that, right, this is a form of abuse to your child, society as a whole thinks so, and we're not going to let that happen. Right, so we're going to get them medical treatment, even though now they don't usually. It's not a child abuse kind of situation where the parents get punished for it, right? Because it's a freedom of religion exercise issue. It's not a violence issue or a neglect issue. If it's actually completely 100% not that, right? In the cases that I've read about this, the parents are never joyfully trying to deny medical treatment for their child. It's painful, it's agonizing. They go through all kinds of anguish about it, but their religious belief is strong enough that they think that's the right answer, even though they don't like it themselves, right? So it's hard to make a case for punishment of parents for child abuse, but the argument from the state side, it is very similar to saying that it is child abuse. So it's, I mean, a lot of really anguishing kind of situations there when we take these issues seriously. And I haven't seen anywhere the parents in these kind of situations aren't taking it seriously. I imagine in some cases where the states step in and force medical treatment, a part of the parents are somewhat relieved because their child's getting treatment and may be fine, but a part of them is also religiously, right, offended because, right, their religious practices have been violated by the government. So I would imagine that's a fairly confusing situation to be in. Another one I want to bring up that I find that we had just a few years ago that brought this kind of to the forefront, and I put it in the slides. Medical technology has got us to the point where we can, through in vitro fertilization and other things, store embryos, right? Fertilized embryos, freeze them, put them away, store them. And we use this practice for a lot of really good things, right? A father or prospective father or mother gets diagnosed with cancer and is about to go undergo chemotherapy or something like that that's going to render them sterile, right? They'll go through this process, fertilize some embryos and freeze them because they're not ready to have children yet. But they need to have this medical procedure that's going to kind of knock their body all out of whack for years. And that in and of itself is a pretty cool thing that we can do in society and help people out that way. The question, though, becomes what happens? What's the legal status of those frozen embryos? And are they property? Are they potential people that have privacy rights? There's a whole medical privacy issue here about who's using these facilities and why, and should that be open up to uh, any kind of policy considerations from the government? And what brings a lot of this to the forefront was a situation where one of these labs that stores these frozen embryos had a complete mechanical meltdown, literally and figuratively. So all of those, all the backup systems and everything that kept these fertilized frozen embryos frozen failed while the facility was closed. All the backups failed. And before anything could be done, all of those embryos were ruined. Is this just a sorry, right? You had a contract to store these here and it didn't work out well and we lost your property issue? Was that a massacre? Is it a form of abortion as far as the privacy issues go? We don't know, right? And this is trying to be worked out through courts where they try to decide what the policies are here and what's the applicable law. So a lot of these things like this around right to die are just real live issues that we don't have legal answers to yet, and it's evolving, right? We're trying to figure out what the answer is going to be, and there's not one on this that I'm aware of that I can share with you. There was obviously a settlement as far as monetary settlement that happened because of this, but as far as teasing out the actual privacy issues, the medical privacy issues, the life issues, and was there death here, and we don't know. The other issue that I've got here is one that we've had some experience with, and that's doctor-assisted suicides. You want to end your life, and doctor has told you you're done for. You certainly don't want to. Oh, yeah, I shouldn't say certainly. A lot of people would not want to take a very dangerous way out of this. Right? They would like their death to be quiet, painless, and dignified. And doctors, right, those that protect our lives and understand how life works, are probably the best suited to understand what the best way is to transition painlessly and quietly, right? And so it's no surprise that the patients have asked doctors in that past to help them. Now, most doctors say no because they take an oath to do no harm and consider assisting with a suicide to be doing harm. But not all doctors. And we had a case where there was a doctor, and he did enough that he became known as Dr. Death, was going around in cases where there were clear terminal life issues. He had a machine that he designed that he would take to people that wanted to die, set it up, and show them how to operate it so that they could push a button and kill themselves through a drug overdose. And by all accounts, he delivered a, it sounds strange to say it this way, safe, effective, quiet process that, allowed people to end their lives in a dignified fashion. And he was going around helping people out from his perspective by setting this up and letting them do this. He was held to be violating state laws and was convicted and sent to jail for, I think, about a decade because he was doing this. So again, it's another one of it goes back to the beginning here when we're making these kind of decisions. Even when we try to bring in experts to do it a proper way. It runs afoul of these kind of concerns and issues. I've forgotten his name, other than his moniker of Dr. Death, but it was up in the Midwest. I can't remember his name, but he was doing this for a while. Thank you, Kevorkian. That's exactly right. Dr. Kevorkian. So we don't know all the answers to these issues. We have policies in place that sometimes work, sometimes don't. We have the government questioning how much they should be involved in this process or not. And there's certainly a concern for the elements of misuse here that we would want the government involved in a sense to make sure that it wasn't being done improperly. But then it puts the government in a position of advocating and assisting the killing of their own citizens. So there's a whole lot of difficult decisions and policies to kind of flesh out here. And I think it's, aside from the abortion issue, which is still obviously a very unsettled topic legal-wise and going forward politically, this other place that we're going to see a lot of this debate between values that go back to protecting civil liberties or protecting our civil liberties from the government, but also the government having some kind of legitimate concern about what we're doing and why. Some states allow you to end your own life. I don't know if they allow doctor-assisted suicide. I think it's Oregon and maybe Washington have some laws on the books that allow people that have been given a terminal diagnosis to have therapy and to choose a way to end their life, and the state is not going to actively try to prosecute or stop them from doing that. But I don't know if it went so far as doctor assisted. So in those states that are allowing this, there won't be that. If you did that in Texas, yes, you attempt suicide and fail, it is possible to get criminal charges filed against you for doing that. That doesn't usually happen because most of the time you try to commit suicide, fail, you're in the hospital, and the charge comes against you that must not be quite in your right mind. And so generally the system looks at it as this person needs psychological assistance and not necessarily jail time. So you'll get probation, or you'll get a case that doesn't get prosecuted. But the law is on the books, right? So yeah, we have the potential to punish you for only for a failed suicide, because otherwise it doesn't make sense, right? So, and when you look at the whole situation, right, when someone's to the point of wanting to take their own life, there are no good policy perspectives from the state side, right? There's not much, right, that you can argue for that the state wants to be involved in this. Yeah, you could go to one of the states that allow it. There are the understanding of what I've read is that the policies in place in those states are meant only for state residents. So they're going to not want to extend the same. They don't want their states to become travel destinations for suicide. I don't want that to sound inconsiderate, right? But I mean, that's what we're talking about here. Someone saying, right, I can do this by not breaking the law if I go here, and the states on that other end are like, please don't do that, right? But if you had enough lead time that you could establish residence, you could certainly do something like that and fall within the legal bounds of that state. Again, these are questions we would have to have, right? What happens if, and I'm making this up, so I don't know if it'll work or not, but let's say as a Texas resident, I left a note saying I'm going to we're going to commit suicide. So I've left a note of intention that I'm going to break the law, right? As a Texas citizen, I'm going to break the law, but I'm going to go to this other state to do it. Would Texas have any right or any interest in getting in touch with the other state and say, stop him before he gets there and return him to us? I don't know. I don't think there's been anything like that, right? But you could see, right, a spouse or a family member going to the state wanting them to intercede and stop this action from happening, right? They're suicidal, they're not in their right mind. Somebody, right, needs to get them and put them under some care, right? You can see that happening, and they're going to be arguing, no, I'm absolutely in my right, and this is what I want to do, and I should have the right as an individual to control my own life. And you can see the argument starting to develop. So, good question. I can't give you a solid answer on that. Just don't know. Anyways, I think I find this interesting because it's so unsettled, and we don't have a solid answer, and we're sorting through these big questions, right? So, kind of something to keep in mind. So I think that should be the last slide in civil liberties. Is there anything that anybody wants to ask on civil liberties before I pull up civil rights? Okay, so again, when we start talking about these things, make sure we're on the same page. We talked about this in the Civil Liberties chapter, so I'll reintroduce it here briefly. Right, when we're talking about civil rights, we're talking about something different than civil liberties. So remember, civil liberties are those protections that we have that keep the government away from us. Civil rights is turning that around, right? Civil rights is where the government is establishing policies to be actively involved in protecting your rights. The impetus for this, the historical push for this, obviously comes out of the government coming to the conclusion that groups have been historically discriminated against in the United States over time. None of us are shocked and amazed by that. And that the government needs to be doing something proactive to address that situation, to stop that discrimination, to deliver, right, due process and the extension of equal rights to all people who are U.S. citizens, regardless, and I say this because this is where most of the problems are, regardless of what the states may be implementing or doing or not doing. So most of this drive is from the federal government trying to come down into areas and states where those states and places have not protected the civil rights of people, have not been doing their job. So there are lots of places in our history for us to talk about discrimination. And so we're going to cover some of that. So, but the idea here is you got to keep in mind is that this is now, instead of like civil liberties where you're trying to keep government from negatively impacting you, civil rights are the cases where the government is coming in to try to right wrongs that have historically been there. The government's acting, right, to try to fix things. So this civil rights is government stay out of my way. Civil liberties is government stay out of my way. Civil rights is we're the government and we're help. Now, how much you believe and trust in the government to help is a different issue, but that's the thrust behind the idea. So we're going to talk about a lot of different forms of discrimination. The idea of discrimination, the concept of discrimination requires us to understand what equality means and to understand that there are different definitions of equality and different expectations of equality in our society. And this is one of the reasons we're having so many discussions about racial inequities, racial discrimination still in the United States. And the different concepts of equality are what gets us the argument between Black Lives Matter and All Lives Matter, right? Nobody in that discussion thinks that they're racist, that they're pushing discrimination. And the reason they think that for themselves is because they have different concepts about the notion of equality. So let's talk about what equality can mean. The one interpretation of what equality is that I call the traditional notion, the one that works across most people in the United States, is that this is supposed to be a country and this is supposed to be a place where everyone has an equal chance, that they have an equal opportunity, right? That the deck is not stacked against them, that if you just apply yourself, work hard, right, you can be successful. That's referred to as, by a lot of people, as the Horatio Alger myth, right? Horatio Alger was a series of fictional stories written in the early 1900s, 19 teens, about people coming from Horatio, right, Alger, coming from a position of nowhere, and through hard work and common sense becomes a successful person. And the story is that it's driving the overarching kind of concept that's driving through those stories is that's what America is, a place of opportunity where Horatio Algers can be successful. We refer to that, generally speaking, or in passing, as the American dream, right? A place that we're here as a place where you can come, right, as a first generation immigrant and work hard and be successful and look after your family and make a life for yourself and your family. And that's a story we've told ourselves, right, for a couple hundred years now. And for some of us, that is true. It's more true. And for some of us, it's less true. And so history can give us a walk through that. Let's look back at our documents, our founding documents, to see what it says about equality and what it says about discrimination. The first thing you're going to see is that our original documentation does not talk about equality. The preamble mentions, right, uses the word, but you don't see it in the Constitution. You don't see it in the first 10 amendments of the Constitution. You don't see anything in our founding baseline documents about how this country is working until you get to the 14th Amendment. The 14th Amendment forbids states from denying to anyone equal protection of the laws. Now think about that, right? The 14th Amendment was 1865, 66, 67, right in that area. It's one of the Civil War amendments, right? So we're, a century practically into the American experience before we get, right, a part of our Constitution that talks about equal protection of the laws. And obviously, in relation to the end of the Civil War, right, this was the federal government trying to amendment to ensure that all U.S. citizens had the right to vote, right? The protection of the laws in the state, protection of the laws from the federal government were applied fairly to everybody because they weren't. And so this is, right, trying to use constitutional perspective to make that begin to happen, to put the states on notice, to give individuals the idea that, hey, you're supposed to get this. That's well into our history at that point. So really, the arguments about civil rights and how we try to make that happen are a century or so old. So equality, right, can mean equality of opportunity. Before I go forward, let me back up. It can mean equality of opportunity, and that's what we call a traditional notion that I was mentioned. But other examples of equality could be equality of result, right? You don't see equality of result arguments very much in the United States, especially if it comes to something about equality in the results as far as economic results. Although when we look at affirmative action, that's trying to look at a history of being denied the opportunity to get education and then putting a system into place to try to address that historical problem by giving equal opportunities to others, and equal results as far as policy application goes, right? So you're going to see these arguments, these two perspectives conflicting with one another. And a lot of our court cases around discrimination today are exactly those kinds of affirmative action cases. We've had a plethora of them here involving the University of Texas, right? And Texas gives, right, incentives to people of color to apply to the University of Texas. And what they're trying to do is trying to ensure that there's a broad spectrum of people's, in that university system. And they think that, right, having people from a lot of different cultures, a lot of different perspectives, whether that's racial or ethnicity or language or geography, that all of those differences lead to a richer college experience, university experience. And so as part of their admissions process, the University of Texas, they take some of those things into consideration. Well, when someone that has the traditional perspective of things and has a high school experience that would normally qualify them for acceptance in the University of Texas gets denied, right? They argue that, hey, you're discriminating against me by making all of these exceptions for other people that aren't based just upon academics. And University of Texas has been sued multiple times for that. And generally speaking, they win those cases. They can make the case that what they're trying to do there is a large social significance, is important, and as a university, they should be allowed to do that. So let's, right, keep in mind that as we approach issues of discrimination, sometimes those are issues that are coming at us from equality of opportunity. People weren't getting a chance. Some of them are coming from equality of results, that, hey, things should be turning out more equal than this, and they're not. And so there's different justifications underlying the approaches to these questions about discrimination. Before we jump into any of the actual cases or anything, though, what I need you to understand is that, and this is an extension of something I said earlier, right? Earlier in the semester, I said constitutions, right, do not guarantee fairness. Constitutions actually bring about bias because they tell you these are the rules that count. Here's how we're going to play the game. And if you're not going to play it this way, you're going to be experiencing bias. So constitutions and the laws that come out of them discriminate all the time, right? It is the norm for legislation to discriminate. Most of the time we don't think about it because the discrimination we're seeing is discrimination that we all agree with. If you hurt someone, you should be punished. So we're going to discriminate against the people that hurt other people, right? And we put that into law, and that discriminates against them. We don't care, right? They've done something that societally we can't abide by. But we do that in a lot of different ways, right? We do that when we say you can't get a driver's license until you're a certain age. You can't vote until you're a certain age. You can't keep driving after, right? If you can't demonstrate use, your facilities are good, faculties are good, right? So laws discriminate all the time between what's proper and what's improper, what you can do and what you can't do, when you can do something, when you can't. So when the courts have to address the issue of discrimination, the first thing they have to do is make sure that the discrimination they're seeing, they have to determine whether it's valid discrimination or invalid discrimination. They have to classify it that way. And if it's valid, it's not going to go very far. And so what the courts have told us over time is that we're going to have a classification system where we run the discrimination that's occurring through, right, an evaluation, and we're going to classify it. And if there's a good reason for that discrimination, we're probably going to say okay. And what they've told us, the actual words they said, is that discrimination that can be deemed valid, right, can be deemed valid if there is a rational relationship to a governmental purpose and that discrimination is not already unconstitutional. So if the Constitution says you can't do this, and the government that's doing the discrimination, whatever that is, has a rational purpose, governmental purpose that backs it up, they can probably do it. So you're down at at a bar, you're having a good time, you got drinks, you're driving home after having drinks, and you realize that you're about to drive through, right, a mandated stop where the police are there checking everybody for sobriety check stop. And you want to say, you haven't seen any behavior from me that I'm inebriated or drunk within outside of legal limits. You got no right to stop me. You're discriminating against law-abiding citizens driving on the road, right? Because they haven't done anything. And the government's going to argue, well, you're right. It is somewhat discriminatory. We're pulling people over and we're checking to see if they're drunk, and we don't have any behavior to base that on. But we know that between these hours and these hours, right, 10 p.m. and 2 a.m. on Fridays and Saturday nights, that about 60 to 70% of the people out there are under the influence. So we've got a rational relationship of providing government safety on the highways that tells us this is the time we should be looking at almost everybody. And so we're going to set up these points and do that. And the courts have said, good enough, right? So they're discriminating against people driving between those hours and those days and people driving all the other times when they're not doing this. But the courts have said that's a rational relationship to the government purpose of having safe highways and safe drivers, so not unconstitutional. So they have set up, the Supreme Court, a classification system about discrimination. And we're going to work through this from the top down. They have told us at the top of this list that classifications of discrimination that are arbitrary, right? In other words, there's nothing systemic or process that makes sense there. They're just arbitrary. If a classification is arbitrary, it's invalid, period. And then they've told us through court cases, any racial or ethnic classification in our mind is probably arbitrary. Therefore, it's probably invalid. Now, is there ever a case where we could justifiably discriminate based on race or ethnicity for good reason? What the courts have said when they considered that question is we don't know. We don't know of one now. We can't think of one in our head. So what we're going to say is that if you as a government discriminate based on race or ethnicity, we're going to approach that as an inherently suspect case. We're going to presume that discrimination to be invalid. And you, the state, the one that's doing the discrimination, the government, must show a compelling reason, right, to do this, to have this discrimination. So the burden rests on the government, right, on the state, not against the people that are bringing the complaint, right? So the people are complaining, I'm being discriminated against because of race or ethnicity. The courts look at it and go, yeah, it kind of looks that way. Government, what do you got to say for yourself? You, right, got to convince us to change our mind because we're coming at this with an inherent suspect, presuming it to be invalid, right? You've got to make the case. So what I have in my mind when I see this and I think about this is the meme where someone's sitting behind a table with a big board on the front, and on it they say some position, and they go, change my mind, right? And so the court's got their table set up and their cardboards out there, and it says discrimination based on race or ethnicity is, right, invalid, change my mind, right? That's the court's position on any policy that a government entity is putting into place that's going to discriminate based on race or ethnicity. So that's a heavy burden. That's a hard case to prove. And so far, states have not been able to prove any case where race or ethnic classification is valid, right? The courts have consistently said no, 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 no. Doesn't mean it doesn't still happen, but when the case gets there, right, the courts are saying, no, this is discriminatory, it's wrong, and we're not going to allow it. So that's the top level, right? That's the hardest, right? If you're going to discriminate as a government, you're going to lose right now if it's based on race or ethnicity. They haven't ruled out the possibility that someday a government could change their mind, but they haven't yet. The next level down under this compelling scrutiny is what we call moderate scrutiny. And this has generally been centered around discrimination based on gender. There are cases, right, to be made, the court says, where gender discrimination is probably more valid, right, than not. But there has to be some substantial relationship to some legislative purpose that the states are going to have to prove to us. Most of the time, decisions have been trending toward gender discrimination being struck down, right? So we're seeing, right, more equality being championed by the courts based on gender discrimination claims. So they see them, they believe that most of the time the legislative purpose is not, there's not a substantial relationship to the gender that requires discrimination to be based on gender. What that means in practical terms is that the court says, well, do you have to phrase it as a gender discrimination issue? So I'll give you an example of how that comes about. My favorite one is firefighters. If you go back not too long ago, women were not allowed to be firefighters. Couldn't even apply. Couldn't go to training school. Couldn't apply. If you're a woman, you could not be a firefighter. You were going to be discriminated against because you're a woman. That got challenged in court. And the court said, well, we could try to say that this is gender, that might be proper gender discrimination, but we don't have to. Because is there another way to do this? What are you actually concerned about? What is your real legislative purpose? And the real legislative purpose was that, as a whole, women could not perform the complete job required of a firefighter. And the court said, okay, like what? And it says, well, most women that would come into the situation couldn't carry a person, right, over their shoulders out of a multi-level building that's on fire and save them. And that's part of the job requirement. And they go, well, are you talking the average person or? And they're like, yeah. And they go, so couldn't you put something into your job requirements that says you have to be able to lift and carry a certain amount of weight that the job requires and then not focus on gender? And if they can do the job regardless of the gender, then. And so what the court did was drove a wedge between this substantial relationship based on gender to the legislative purpose. And they said, right, we can redefine this as the practicalities of the job and not look at the gender at all. And then, right, the discrimination for gender has to go away. And that's exactly what happened. And so now you look at the requirements to be a firefighter and they're job related specific, right? Lift this weight, run this far, carry this hose, hold this, right? If you demonstrate that capability, they don't look at gender, right? That's not part of the criteria anymore. And if they do, they're stepping outside the proper relationship here of the how we apply this. So at this substantial relationship level, right, this moderate scrutiny, most of it has been revolving around jobs and job capabilities. And if you redefine the job and can defend those job descriptions off of what the job really entails, then you can discriminate. But you don't discriminate saying no women or no men or no, you don't do that. You say, here's what it takes to do the job the way we want it done. And that, right, is trying to settle that issue and is where the courts are going on this. And it's been rather successful, right? So this is the moderate scrutiny. The states, the governments, the businesses, don't have to, they have to prove a substantial relationship, but that's much less than a compelling reason, right? That we had under the strict scrutiny at the top. But most of it has been trundled off down toward looking at the actual requirements of the job. There are probably very few jobs that you can think of that require a gender, a particular gender. And I'm drawing a blank at this moment, but I'm sure there are some. If we move the next level down, we get to what we refer to as the reasonableness level. This is where discrimination is much easier to justify, and we can codify it into law. If discrimination can be argued to meet a rational, to be rational and to meet a legitimate government goal, we probably make it stick. And this is where we're going to see things like age, where we see most of our codified discrimination happening, right, come into play and make sense. You're not going to make, a 4-year-old or a 6-year-old eligible to get a driver's license, right? It's just, you can't, it's not reasonable. It doesn't make sense. Now, does that mean that they can't drive anything at all? No, there's some cases where you'll find 10 and 12-year-olds driving tractors and things like that, but on the roads, not so much. Getting the license to do it, not so much, right? There are extenuating circumstances that do push age limits up and down, which, right, goes to the point of proving that they are reasonable if they're looking at the actual circumstances, right? You can get a hardship license in Texas and drive at 14, I believe. And for everybody else, you really get your start at 16. Okay, refuse to hire men. Okay, well, okay. This is at a church, religious oriented. That's a very private situation where there's some extenuating circumstances, right? And so even when the men volunteered, they wouldn't let them, they would let them in the daycare, but they wouldn't let them change diapers. Well, they might have a case, right? if they wanted to sue the church for that, right? Because what's the policy that the church is putting into place there? It's gender-based, so there's got to be some kind of social relationship to what's going on here, to why they're saying no. And it looks like if it's because of the diaper changing, they're afraid that men are what? Not capable of getting the tape to stick to the diapers, not capable of wiping a butt properly, right? I imagine there are a whole lot of fathers out there that are pretty capable at changing a diaper, and could do just fine at it. So if they sued, right, they would say, look, right, here's the jobs that's required. I can do all these. Why aren't you hiring me? And the church would have to make the case that there was something there that women could do that men couldn't do. They would lose that case almost certainly. Now, in a church situation, the men that are wanting to do this are members of that church. What are the chances that they're going to sue their church to do that volunteer work, right? So in a real sense, you've got a reality kind of situation that's going to prevent this from being challenged in court, probably, because no one would want them at that church worshiping if they took the church to court. And that's a voluntary kind of association, so you're probably not going to get a case out of there, and you're probably not going to get a court that wants to pick it up. So these are not guarantees that there aren't going to be discrimination happening, which you're seeing, you're telling us there. But they are how the courts would approach it if the case were brought to them, right? So there's a lot that goes into determining whether that's going to happen. I just realized that it's 2:52, and so I'm well past my time to shut up and let you guys move on. So I will. And we will pick back up here next week on finishing off slide 8 and moving on to slide 9.